So we have a small topic from Constitution Unit 4, okay? We'll discuss that. It's just two articles that are included there. We'll discuss that topic. Plus one more is remaining from Unit 4. After that, Unit 4 will be done. I'll share the entire notes for the unit, okay? So we discussed regarding subordinate judiciary, right? That Supreme Court, High Court, under that we had all these divisions, civil and criminal for metropolitan areas, other areas. We had all that division. That is subordinate court. Along with that, we have another provision, that is administrative tribunals. So what are administrative tribunals under Constitution of India? There are only two articles mentioned for this provision, and initially these were not part of the Constitution. When Constitution of India came into force, at that point in time, these provisions were not part of it, but it was inserted at a later stage only through an amendment, that is the 42nd Constitutional Amendment. It inserted this provision. Okay, so there are two articles and one specific part in the year 1976. 1976. So 42nd Constitutional Amendment Act 1976, it inserted part 14A. Part 14A to the Constitution, and also it inserted two articles, 323A plus 323B. Both these provisions are relating to tribunals. So they provide for constitution of tribunals dealing with administrative matters plus other issues. So there are two different types of tribunals that this part talks about. First one is for administrative matters. Administrative tribunals need to be set up, plus other matters, other additional matters for which tribunals can be set up. Like one day you were saying like ITAT, yes, like ITAT and other different matters. Also, tribunals can be set up. Those provisions come under section 323B, and for administrative matters, it comes under section 323A. Both of these are part of part 14A of the Constitution, which was inserted in 1976 by the 42nd Constitutional Amendment. Okay, so according to these provisions of Constitution, tribunals are to be organized and established in such manner that they do not violate integrity of judicial system given in Constitution, which forms the basic structure of Constitution. That means we do need administrative tribunals, we do need tribunals for other different matters, but these tribunals should not go against the integrity of this established system. Like we have our regular courts, we have Supreme Court, High Court, subordinate courts. So tribunals should not take away rights of these traditional courts or should not in any way affect them, but rather we would need these courts in order to help or assist the regular courts, right? So for that purpose, we need to set up tribunals as well. Introduction of Article 323A and 323B was done with the primary objective of providing an efficacious alternative institutional mechanism or authority for specific judicial cases. Like you must be knowing that these tribunals are only applicable for one specific area. When we say service matters, it only applies to service matters. When we say ITAT, it only applies to income tax. Right, so similarly, these would be applicable for the specific areas or specific matters only, wherein they will act like an alternative institutional mechanism, an alternative setup for those specific matters only they would deal with. The purpose of establishing tribunals to the exclusion of jurisdiction of high courts was done to reduce pendency and lower the burden of cases, whether it's the subordinate courts, whether it's the high court. Might be they would mention that they are like at the same level with high courts and you need to approach those courts only for your specific matters. Therefore, tribunals are organized as part of civil and criminal court system under the supremacy of Supreme Court of India. They would come under the Supreme Court, but they may be at the same level with High Court or some civil or criminal courts. We may have tribunals for all these different matters. Some may be civil, some may be criminal also. Accordingly, they will be set up. From a functional point of view, administrative tribunal is neither an exclusively judicial body nor absolutely administrative body, but it's somewhere in between the two. That's why administrative tribunals are called as quasi-judicial body. They are not like judicial body like the regular courts, but they perform the function of administrative body, plus they also act like a judicial body. They may also issue some rules, regulations, notifications relating to that specific area. Plus, they may also give some suggestions, advices. They may also hear cases, help parties to come to a settlement, or pass an order just like the regular courts. So they are a little different from how traditional courts function, but they also have sort of judicial, sort of administrative combination of both the two functions, and they will apply for those specific areas, those specific matters, may function like a civil or criminal court system. Characteristics of administrative tribunals, whether it's a service matter or for any other matter. Okay, so what we have is, like, it's a statutory body, right? It would have a statutory origin. Even though Constitution is talking about its establishment, but it is not mentioning the details relating to it, right? So Constitution is what? It's like a basic document saying that, yeah, we do need these sort of bodies. But then details are not being provided. It will have a statutory origin. Like in case of ITAT, you would see we have a legislation, right? We have Income Tax Act, and under that ITAT is being set up. Similarly, all these bodies should have a statutory origin. Like Constitution is just saying that for these matters like income tax, service matters, cested, whatever, we need to establish tribunals, but then those would be set up based on their own legislation, right? Under a specific legislation, it will have its origin. So they are considered as a statutory body, right? Under the statute, they are being established, their powers, functions, appointment, everything is being mentioned. They must have some features of ordinary court, but not all of them. Just like how ordinary courts function, they can also pass an order, then help parties come to a settlement and all that stuff, but they may not have all the functions like a court. They may slightly be a little different as they are having some administrative powers or functions. An administrative tribunal performs quasi-judicial and judicial functions and is bound to act judicially in every circumstances. Whenever a matter comes before them, they would accordingly decide the matter. Sometimes they may perform administrative functions by issuing some notifications, laying down some guidelines, whatsoever it might be. It's a little different from the regular courts that we have. Next is administrative tribunals are independent and not subject to any administrative interference in discharge of their functions. So under the statute, everything will be mentioned, who all will be the members, its composition, their appointment, term of office, salaries, powers, functions, everything will be mentioned. And in that same way, like an independent body, they need to perform their functions. Okay, so what is happening is they are not coming under any Supreme Court or High Court like the subordinate courts we have, but they are independent bodies. They would perform their own functions relating to that specific matter or area. In the procedural matters, the administrative tribunals possesses powers of a court to summon witnesses, administer oath, to compel production of documents, etc. Just like how regular courts have the power that if there is a case filed against someone, court can issue summons, warrants, seizure of property. Court can ask or compel persons to appear before it. Same power is given to these tribunals also. They can also ask for production of documents, they can seize documents, whatever is needed to finally give a decision, decide a matter, those functions or those powers they will have. Tribunals are bound to abide by the principles of natural justice. What is natural justice? It basically means principles like you cannot judge your own matter. Like if there is a dispute between you and me, and if I am allowed to decide the matter, there is every possibility that I will give a decision biased towards me. I would think about my own benefit, my own, like my own self. So that should not be allowed. Disputing parties should not be allowed to be judged in their case. It has to be some neutral person who is not related to these two persons. It also means you cannot give a decision without hearing both the sides. You need to hear both the sides, after that only give a decision. Okay, so those are natural justice. Same would apply for them also. Tribunals also accordingly need to function. They are not like something different. Whatever they wish they can do, that is not the case. Okay, is this part clear?
Yes, madam.
So that is in general what tribunals are, their functions or characteristics. Now we have different types, like two different types of tribunals, right? Categories of administrative tribunal. First of all, we have administrative tribunal for service matter, which is given under the first article, Article 323A. So Article 323A, it provides for establishment of administrative tribunals by law made by the parliament. Okay, so again, even though Constitution is talking about its establishment, it does not mention the details. Those details need to be mentioned by law made by the parliament only. Okay, so section 323A, it talks about establishment of administrative tribunals. It will be done under a legislation of parliament for adjudication of disputes, complaints relating to recruitment, conditions of service of government servants under central and state government. Accordingly, for various states, we have state public service tribunals. They would decide those matters. They are given that power. But then they are not getting their powers, functions, establishment from Constitution, but it is coming from a specific statute which we have. It includes the employees of any local or other authority within the territory of India or under control of Government of India, or for a corporation owned or controlled by government. So accordingly, while these tribunals are set up, it would also mention their powers, functions, in what all matters they would apply, in what all matters they would not apply. Everything would be mentioned. Accordingly, based on the statutory functions or statutory rules, they would also work. The establishment of such tribunals must be at the central or state level separately for each state or two or more states. Like there can be one state public services tribunal which is functioning for more than one state also if needed. The law must incorporate the provisions of jurisdiction, power, authority to be exercised by tribunals. The statute would provide for all those details. The procedure to be followed by the tribunal, exclusion of jurisdiction of other courts except Supreme Court. So it may also mention that just because we have income tax appellate tribunal set up for income tax related matters, you should not be going to the magistrate's court. But if you are not happy with the decision of maybe ITAT, you can file an appeal to the higher courts. Okay, so whatever is mentioned, accordingly it will be followed. So for service matter, first provision we have under section 323A, under the statute, everything will be mentioned. Accordingly, these bodies also will function. Okay. This is clear, right? It's a very simple provision we have. Similarly, for other matters, right, certain other matters like assessment and collection of tax, foreign exchange, industrial dispute, then some land related matters, elections, production of supply, food, etc., rent regulation, for various matters also accordingly, tribunals can be set up. This is given under Article 323B. Okay, so Article 323B also empowers Parliament plus state legislature. If the matter is coming under state law, state list, then state legislature will have power, otherwise central parliament will have power. So Parliament or state legislature is having power to establish tribunals for the adjudication of any dispute or complaint with respect to matters which are specified under this article. Accordingly, there may be tribunals set up for matters relating to tax, foreign exchange, industrial and labor disputes and all that stuff. Those tribunals would have specific powers and functions relating to those specific matters only. Again, these are also set up under some statute. These are statutory bodies. Even though Constitution of India is talking about its establishment, they are not established under Constitution. They are statutory bodies established under different statutes only. But if you talk about Election Commission of India, if you talk about these other bodies, right, Election Commission we have, then we have UPSC, all those bodies we consider as statutory bodies, like constitutional bodies, because Constitution is talking about their composition, establishment or some other details. Okay, but with regard to these tribunals, Constitution is not making any express provision. It has only mentioned that we need tribunals for these matters. Accordingly, by a legislation, we need to establish it. So these are statutory bodies only. Such a law, whatever law is passed by Parliament or state legislature, such a law must define jurisdiction, powers, and all the other composition, etc. of those tribunals, and also the process, how we need to approach the tribunal, what are the different stages of filing a case, complaint, or a dispute, how matter will be dissolved, all those things also will be mentioned in that specific statute only. Okay, similarly, you will see that there might be different heads under the same establishment, that for these matters you can go here, for this matters you can go here, like that. There may be some specifications given under the statute itself. So there was a case L. Chandra Kumar versus Union of India, wherein the court reached various conclusions as to jurisdictional powers of tribunals, which are constituted under these two articles, for service matter or for other general matters. When a tribunal is being set up, what is their jurisdiction or what is their power? Supreme Court struck down two provisions under these articles on the ground that they excluded jurisdiction of High Court and Supreme Court. So what happened basically, right? These tribunals are always considered at the same level or might be lower than High Court. Okay, if you are not satisfied with decision of these tribunals, you can go file an appeal in the High Court or Supreme Court. That provision is there for almost all the tribunals. But by this 42nd amendment, when these provisions were inserted, right, what government tried to did, like there was this clash going on between judiciary and parliament. Okay, there was clash. Like if you remember, when we were discussing amendment of Constitution, Article 368, that time also I told you that this article has gone through so many changes just because there was a continuing clash between judiciary and parliament, that who is supreme, is parliament supreme or is judiciary supreme. So during this process only 42nd amendment also came, and just to reduce power of courts, what parliament did is they said that we can establish certain tribunals and we would give exclusive power to these tribunals only. whatever decision is given by these tribunals, that will be binding. No appeal before Supreme Court or High Court. Okay, so what this amendment did is they excluded jurisdiction of Supreme Court or High Court through these clauses. Okay, and accordingly, case was filed, L. Chandrakumar versus Union of India, wherein validity of these articles were questioned. That Supreme Court and High Court is like the topmost court. Can we exclude jurisdiction of Supreme Court and High Court? That parties cannot approach these courts even if they are not satisfied with decisions of tribunals. Accordingly, case was filed and court said that no, if your right is being violated, you have a right to file a writ petition in Supreme Court or High Court. That right cannot be taken away simply by a constitutional amendment. So it was held that these provisions relating to establishment of tribunal and stuff, these provisions are valid, but this clause that is excluding jurisdiction of Supreme Court or High Court, that clause is invalid. That clause was basically struck down by Supreme Court. Okay, and accordingly it was said that yes, you can establish tribunals, but you cannot give complete jurisdiction to them, because what might happen is, for some important matters, right, government may appoint their own favorite people who would favor them, those people as chairman or members of the tribunals, and accordingly decisions will be given in favor of government whenever a matter comes before the tribunal, right? So in order to check those things, it was said that no, you cannot simply exclude Supreme Court and High Court, because Supreme Court and High Court, as we know, are like independent bodies, right? We studied independence of judiciary. So that is the reason why in this particular case, these provisions were struck down, that you cannot simply exclude jurisdiction of Supreme Court and High Court by way of an amendment. Okay, they are the supreme body and they will have power and control over it. Is this part clear?
Yes, madam.